Now, the allegations against the chief registrar have reignited debate on the thorny issue of judicial reforms. Shollei had embarked on a raft of reforms that are now at the center of this latest saga. So is she a villain of graft or a victim of powerful cartels in the judiciary? KTN's Asha Mwilu takes a closer look.
Just 2 weeks ago, Gladys Shollei and the Chief Justice made an impromptu tour of the Milimani law courts and made this promise.
What we have done is gone there to improve. We are re-engineering the process of the registry.
Minutes earlier, she had taken the Chief Justice, Willy Mutunga, through the ongoing reform projects at the courts. The same projects that have now landed her in hot soup.
I have built my reputation over the years as an honest and hard-working woman in the public service. This was until the JSC made the unfortunate, irregular, and procedural and irresponsible decision.
As Chief Registrar of the Judiciary, Shollei runs a powerhouse that puts her at the epitome of all operations in the third arm of the government.
The Chief Registrar's role is more or less a one-man's job to do almost everything in the judiciary. Either finances, human resource, management itself, administration itself, even in terms of transferring for personnel, including judges from one station to another.
The powerful role of the Chief Registrar's office means that with all projects and operations of the judiciary, the buck ultimately ought to stop with Gladys Shollei.
Ultimately, all these persons report to the Chief Registrar. Nothing is done by these people without the involvement and without the consent and concurrence of the Chief Registrar. That is why eventually it is her who is responsible.
Shollei has been at the forefront of attempting to complete the task of reforming the judiciary, a job that began with a so-called radical surgery in 2003 but never made much headway. Judiciary analysts say that during her tenure, Shollei has spearheaded the decentralization of the Court of Appeal aimed at confronting the backlog of cases at the country's second highest court. This, according to insiders, has eliminated huge allowances appellate judges would claim while on duty outside Nairobi. She has also bought buildings to be occupied by the Judicial Service Commission, judiciary staff, and the Court of Appeal. Shollei further introduced an efficiency management system to improve the organization of case files. But now, some of legal experts argue that she may be a victim of corrupt cartels in the judiciary.
She has done everything within her ability to ensure that there is greater transparency, that networks of corruption on matters related to procurement in the judiciary are dealt with.
A possibility she alluded to 2 weeks ago.
You know, whenever there's chaos, there are those people who benefit from the chaos. So they will be unhappy, of course, if you try and streamline the chaos. But there are those who've been suffering on account of those chaos who are very happy.
As the probe into Shollei's conduct begins, the intrigues of the judiciary will be followed closely, especially coming at a time when the succession of Dr. Willy Mutunga as Chief Justice is well underway. And in the next 2 weeks, it will become clear whether one of Kenya's most powerful women in the legal fraternity is a villain of corruption or a victim of malice. Asha Mwilu, KTN, Nairobi.
Well, and I'm joined by Charles Kanjama, who's a lawyer and also council member of the Law Society of Kenya. Charles, thank you very much for making time to speak with me this evening. We don't have so much details, Charles, about these happenings, but why I'm interested to talk to you tonight is just to talk to me about the rule of natural justice, Charles. As compared to what we know now, what's your comment about that?
First of all, James, maybe I could begin by explaining what the Constitution requires in a situation of this nature. First of all, you have Article 47 of the Constitution, which requires that any administrative action of this nature must be fair. It must be efficient, it must be procedurally fair and reasonable. In addition, there is a requirement under Article 236 of the Constitution that whenever you want to subject a public officer to any disciplinary action, you shall follow due process of law. You shall not victimize them. You shall not subject them to that disciplinary action without due process of law. And of course, the question is, has what has taken place complied with the Constitution? Because even this compulsory suspension is a disciplinary process. And what the Chief Registrar of the Judiciary has said, James, is that under the Judicial Service Act, there are a number of remedies that can be taken for an officer who has misconducted or who is suspected of misconducting themselves. This include suspension and interdiction and even reprimand. But nowhere in the law is there a procedure for compulsory leave. So these are some of the concerns that have been raised, and I think we as Kenyans and we as members of the legal profession in particular will be keenly watching to see is the Judicial Service Commission, which should be really the exemplar of fairness and justice, are they practicing it in this case involving the Chief Registrar of the Judiciary?
So Charles, having pointed that out, in terms of the law and what is provided for in the law, the JSC claims that there are financial impropriety that are involved, in this particular matter. Are we saying that this process, in the end, can be challenged in a court of law? And what are the rights of the Chief Registrar as at this point?
Of course, it can be challenged in a court of law, James. I think the real concern we have is that the allegations by themselves, having been made in public, already damaging the reputation and character of a state or a public officer. They are very serious allegations, and my expectation would have been that allegations of such nature would not be made in public without having afforded the Chief Registrar of the Judiciary an opportunity, really, to respond to the issue. So I find it to be really surprising that she would come out and say she doesn't know anything about the probe that has been begun. But having said that, we have to wait and see what are the substantive merits or demerits of the claims and allegations against her. Definitely the Judicial Service Commission has a mandate, a very strong responsibility to ensure integrity in all its officers, and they must act very promptly when they have any suspicion of impropriety. Yet I wonder whether the approach they have followed of publicly sending an officer on compulsory leave without having given them notification is the right way to go. Interestingly, James, the Chief Justice noted that even that decision was a split decision, 5-4, which is showing that there's a lot of division in the Judicial Service Commission. Kenyans are watching because this is a big test for the judiciary. If they fail this test, it's going to be a big disappointment to all of us Kenyans who are hoping that the reforms in the judiciary really have settled.
Well, Charles, to a judiciary that has been trying to claw back or trying to explain itself after that Supreme Court ruling that just a few months ago, as a member of the LSK and the judiciary in a sense, do you think these happenings today will help the judiciary in terms of getting better, and trying to say, listen, we're opening up, and we're over all these reforms that are coming up, and how will the public react to this institution that now is at the center of these claims?
James, I cannot talk for the Law Society of Kenya. I'm just one member of the Law Society. I can talk for myself and as a person who's keenly interested in reforms as an advocate and as one of the members of the Law Society of Kenya. I think what has happened today is, even without knowing whether there is substance to the allegations, it is a bit disappointing. I think they would have used a different approach in addressing disciplinary issues. Keep in mind, James, that all Kenyans who have problems of disciplinary nature in their places of work, they go to the judiciary to seek recourse. And the Judicial Service Commission is really the senior-most body in the judiciary. Of course, you can challenge a decision of the Judicial Service Commission in court, but the Judicial Service Commission has to consider themselves like Caesar's wife. They have to be above reproach. Everything they do cannot have even the whisper of lack of due process. And I think what we have seen so far is leaving many serious questions in the minds of Kenyans about, is this the right way to go about this process? Definitely they have to fight corruption, but as your story has put it, is Gladys Shollei the victim, the villain, What are the facts? That is what we want to know.
All right, Charles, one final question, Charles. Just the last few months, we've seen people in public office, the NSSF boss who was let go out of what it was called gross misconduct. We've seen the KEBS MD then also fired out of what they called also gross misconduct. And we've seen claims even against Minister for Mining, that is Honorable Najib Balala, on bribery allegations. We don't seem to have a way of how to deal with issues of integrity and corruption, Charles, as a country, do we?
We do have a way. The Public Officer Ethics Act has a system. The different laws in this country and the Constitution have an approach. We cannot adopt a very soft approach which allows corrupt officers to remain in office and continue engaging in corruption as investigations are going on. Neither can we adopt an approach which is so hard and at the merest whisper of an allegation, you terminate those officers. And the Constitution requires due process. Article 47 requires fair administrative action. In the case of public officers, there's a requirement. That requirement involves a number of particulars. One, you have to inform. There's a duty to inform the officer involved. The principles of natural justice. They have a right to be heard before adverse disciplinary decisions are made against them. And then no one should be a judge in their own cause. Really, the person who's complaining against a particular officer should not be the one who constitutes the tribunal to hear the allegation. These are basic principles of natural justice. Someone is entitled to reasons, entitled to adequate time to prepare their response or their defense. There are a number of criteria that day in, day out in the employment courts, the industrial courts in Kenya, lawyers are arguing cases of employees who've been wrongly dismissed. And the members of the Judicial Service Commission, of course, know about all these requirements.
Charles Kanjama, LSK Council member and a lawyer, thank you very much for making time to speak with us. Always a pleasure picking your brains. All right. Now, here now is a look at Gladys Shollei's journey to where she is today. Gladys Shollei holds a Master's of Law degree from University of Cape Town, specializing in maritime environment law. She also holds a Master of Business Administration on degree from Jomo Kenyatta University, a Bachelor's of Law degree from University of Nairobi, and a Diploma in Law from Kenya School of Law. Now, she joined the United Nations Environment Program as an international waters consultant and taught the law of the sea at the University of Nairobi. She then became the assistant editor at the National Council for Law Reporting, where 5 years later, she was appointed as CEO. In 2009, Shollei was installed as the Deputy Chief Electoral Officer for the Interim Independent Electoral Committee, a position that sprang her career in the judiciary. She was then appointed as an advocate in the judiciary, a position she held for 15 years. It was in 2011 that Gladys Shollei was appointed as Chief Registrar in the judiciary.